Before we begin, a quick and important disclaimer. The following content is intended strictly for educational and entertainment purposes and does not constitute legal advice. The history and practice of law are subject to complex jurisdictional variations and evolving statutes. Therefore, this deep dive should not be used as a substitute for professional counsel. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed attorney for any specific legal matters. In 1950, if you wanted to end your marriage in the United States, you didn't just walk into a courthouse and sign a paper. You had to prove a crime. You had to stand before a judge and cast your spouse as a villain, a perpetrator of adultery, cruelty, or desertion. If you couldn't prove a specific fault, the law effectively forced you to stay married against your will. This created a massive underground market for staged photos, hired paramours, and private investigators. It was a world of migratory divorce, where wealthy elites fled to Reno, Nevada, just to escape the rigid moral codes of their home states. But today, the landscape is unrecognizable. We live in an era of no-fault dissolution, a multi-billion-dollar industry where the divorce attorney is no longer just a legal representative, but a high-stakes negotiator, a financial forensic expert, and a strategic architect of family restructuring. How did we get here? How did the American legal system go from "till death do us part" to a system where nearly half of all marriages are dissolved through a highly standardized, professionalized process? This deep dive masterclass solves a fundamental problem for the modern American viewer: the lack of clarity regarding the machinery behind family law. Whether you are interested in the evolution of civil rights, the economics of the legal profession, or the sociological shifts of the last century, understanding the history of the divorce attorney reveals the hidden blueprints of the American family unit. By the end of this series, you will understand the potential outcomes of legal precedents, the historical trends that shape modern custody battles, and the case studies that transform divorce from a social stigma into a civil right. To understand the modern attorney, we must first look at the fault-based era. In the early 19th century, divorce was a rare legislative act. In many states, you actually had to petition the state legislature to pass a private bill just to grant you a divorce. This meant that for the average citizen, divorce was functionally impossible. The legal profession, as we know it, didn't have a divorce niche because there was no volume of work to sustain it. However, as jurisdiction moved from legislatures to the courts, a new breed of practitioner emerged. These early attorneys operated in a system defined by adversarial combat. Because the law required a guilty party and an innocent party, the attorney's job was not to find a middle ground, but to destroy the reputation of the opposing spouse. The data from this era shows a fascinating correlation between strict laws and creative legal workarounds. For instance, in New York, which famously maintained adultery as the sole ground for divorce well into the 20th century, attorneys and their clients engaged in what was known as the divorce charade. Case studies from the 1920s and 30s reveal a standardized procedure. A husband would hire a woman to be photographed with him in a hotel room, fully clothed, perhaps just sharing a drink, and a private investigator, often tipped off by the husband's own attorney, would burst in to catch them. This evidence would then be presented in court to satisfy the statutory requirement. The attorney's role was essentially that of a producer in a scripted play. This period highlighted a massive disconnect between social reality and the letter of the law, creating a vacuum that the legal profession eventually filled with more sophisticated, and eventually, more ethical frameworks. As we moved into the mid-20th century, the economic landscape of the U.S. began to shift, and with it, the nature of marital property. The post-war era saw the rise of the middle class, home ownership, and pension plans. This added a layer of complexity to the divorce attorney's role. It was no longer just about who did what in the bedroom, it became about who gets what in the bank account. This led to the emergence of the attorney as a financial strategist. We began to see the integration of accounting principles into the courtroom. Attorneys had to understand the valuation of a family business, the future value of a veteran's pension, and the tax implications of alimony, which at the time was almost exclusively paid by men to women to prevent the innocent wife from falling into poverty. The true turning point, however, occurred in 1969, when California Governor Ronald Reagan signed the Family Law Act. He inadvertently unleashed a revolution. This was the birth of no-fault divorce. For the first time, a spouse could cite irreconcilable differences as the reason for the split. They no longer needed a villain. While this was intended to reduce the acrimony of the process, it actually expanded the scope of the divorce attorney's work. Without the need to prove fault, the focus shifted entirely to the two pillars of modern family law: equitable distribution and the best interests of the child. Consider the historical trend following the 1970s. As more states adopted no-fault statutes, the volume of cases skyrocketed. This created a gold rush for the legal profession. Specialized bar associations were formed. The American Academy of Matrimonial Lawyers, founded in 1962, saw a surge in influence as practitioners realized that family law required a different set of skills than criminal or corporate law. An effective divorce attorney now needed to be part psychologist, part tax expert, and part peacemaker. The shift toward mediation and collaborative law in the late 20th century represents the most recent evolution in this timeline. Instead of the scorched earth tactics of the 1930s, modern attorneys often market their ability to keep clients out of the courtroom entirely, focusing on the potential outcomes of a negotiated settlement rather than a judge's decree. Step by step, the profession moved from the shadows of social taboo into the light of a standardized civil process. In the early days, a divorce attorney was often seen as a shyster or a bottom feeder of the legal world. But as the complexity of the American household grew, incorporating dual income traps, complex debt structures, and the nuances of joint custody, the attorney became a vital safeguard for the individual's future. The case studies of the 1980s, particularly those involving celebrity divorces and the valuation of fame as a marital asset, further pushed the boundaries of what these professionals could achieve. They began to argue for human capital as a divisible asset, forever changing how we value domestic labor and professional support within a marriage. To understand the attorney of today, you have to realize they are navigating a system that is still catching up to modern technology. We are currently seeing the rise of digital forensics in divorce law. An attorney in 2026 isn't just looking at bank statements. They are looking at cryptocurrency wallets, social media metadata, and geolocation history. The history of the divorce attorney is a mirror of American history itself, reflecting our changing views on morality, gender roles, and the definition of a fair shake. We have moved from a system of punishment to a system of transition. This evolution has massive implications for anyone navigating the legal system today, as the precedents set by the pioneers of family law continue to dictate the division of billions of dollars in assets every single year. Through this academic lens, we can see that the divorce attorney didn't just respond to social change, they were often the primary architects of the new American social contract. To understand how the modern U.S. divorce attorney became a central figure in the American legal landscape, we must look at the colonial era, where the seeds of our current adversarial system were first planted. Imagine you are a resident of the Massachusetts Bay Colony in the year 1700. If your marriage was failing, your options were not determined by a specialized attorney but by the religious and moral convictions of the local magistrates. In these early days, the concept of a dedicated divorce lawyer didn't exist because marriage was viewed as a civil contract that the state had a vested interest in maintaining for the sake of social stability. When a rare petition for divorce was granted, it was usually for extreme cases of desertion or bigamy. The historical trends of this era show that the legal focus was on preservation, not dissolution. Attorneys of that period were generalists who handled land disputes and criminal defense. Family law was a peripheral, often ignored, subset of the law. As we transition into the 19th century, the role of the legal professional began to shift as the United States expanded and individualized. This era introduced the concept of judicial divorce, moving the power from the state legislature to the courtroom. This shift created a massive demand for a new kind of specialist, the domestic relations lawyer. Let's look at a case study from the mid-1800s. Consider a woman named Sarah living in New York in 1850. In a time before the Married Women's Property Acts were fully realized, Sarah's legal identity was effectively merged with her husband's under the doctrine of coverture. If Sarah wanted a divorce, she needed an attorney who could navigate the complex web of fault-based statutes. Her attorney had to be a master of the investigative arts. This was a time before forensic accounting or digital footprints. Evidence was gathered through physical surveillance and the testimony of neighbors. The potential outcomes of such cases were often binary. Either Sarah proved her husband's adultery and won her freedom, or she failed and remained legally bound to a person she may have feared or loathed. The rise of the professional divorce attorney coincided with the emergence of the Reno divorce phenomenon in the early 20th century. This is where the business of divorce became a sophisticated industry. Nevada realized that by shortening its residency requirements to just 6 weeks, it could become the divorce capital of the world. Attorneys in Reno didn't just practice law. They became architects of a logistical pipeline. They coordinated with dude ranches where clients would stay to establish residency, managed the public relations of high-profile socialites, and navigated the jurisdictional conflicts that arose when other states refused to recognize Nevada's decrees. This era proved that the legal profession could be incredibly adaptive to the market demands of the American public. Data from the 1930s shows that Reno was processing thousands of divorces annually, a historical trend that highlighted the growing gap between restrictive local laws and the actual desires of the population. Imagine if you were a high-society New Yorker in 1940 named Michael. Your local laws made divorce nearly impossible without public scandal. Your attorney would advise you on the migratory legal strategy. This involved a step-by-step process of establishing a paper trail in another state, a strategy that required precise timing and absolute legal accuracy to avoid charges of fraud or bigamy upon your return. This specific historical context birthed the strategic mindset that modern family law attorneys use today. It moved the attorney away from being a mere advocate in a courtroom to being a strategist who manages cross-jurisdictional risks and long-term asset protection. As we entered the post-World War II era, the complexity of the American household evolved again. The 1950s and 60s saw the emergence of the suburban middle class. For the first time, significant portions of the population had assets worth fighting over: the family home, a sedan in the driveway, and a corporate pension. The divorce attorney's toolkit had to expand to include early forms of valuation. This wasn't just about who got the children anymore. It was about the equitable distribution of the American dream. Case studies from this period revealed the first major battles over what constitutes marital property. Is a professional degree obtained during the marriage an asset? Is the appreciation of a premarital investment subject to division? The attorneys who tackled these questions were the first true specialists in what we now call matrimonial law. In the 2026 legal landscape, we look back at these mid-century practitioners as the pioneers of the current system. They were the ones who argued the landmark cases that eventually led to the Supreme Court's involvement in family matters. By the time the 1970s arrived, the legal profession was ready for the no-fault revolution. But the transition wasn't as smooth as the history books suggest. When California passed the first no-fault law, attorneys had to completely reinvent their business models. If you no longer needed to prove fault, what were you selling? The answer was expertise in the new, complex formulas of child support and alimony. The potential outcomes for a client shifted from total victory or defeat to a negotiated compromise. This gave rise to the attorney as a negotiator. In the 1980s and 90s, the focus shifted toward the psychological impact on children. This led to the integration of social workers and child psychologists into the legal team, a practice that is standard in 2026. The modern U.S. divorce attorney is now the hub of a multidisciplinary wheel. They manage the financial analysts who track down hidden assets in the form of cryptocurrency or offshore accounts. They coordinate with mental health professionals to draft parenting plans that actually work. And they utilize sophisticated software to project the long-term tax consequences of various settlement options. To understand the depth of this profession, consider the sheer volume of data handled in a modern case. An attorney in a high-asset dissolution in 2026 might review 10 years of digital banking records, thousands of encrypted messages, and complex business valuations that span multiple continents. This is a far cry from the colonial magistrate deciding a case based on moral standing. Every step of this evolution was driven by a need for greater precision and fairness in a society that was becoming increasingly secular and economically complex. The history of the U.S. divorce attorney is not just a history of laws. It is a history of the American family's struggle to find a way to end a contract with dignity and financial security. The historical trends suggest that as long as the definition of family continues to evolve, the role of the attorney will follow suit. We are now seeing the emergence of pet custody cases, the division of digital legacies, and the legal recognition of multi-parent households. Each of these developments requires a legal professional who is not just a master of the existing code, but a visionary who can argue for new precedents in an ever-changing social landscape. The deep dive into this history reveals a profession that has moved from the fringes of the law to the very center of the American domestic experience. But as the role of the attorney became more specialized and the industry grew into a multi-billion-dollar machine, it also became more expensive and more exclusive. This created a new tension in the American legal system: the divide between those who can afford the tactical genius of a top-tier firm and those who are left to navigate the bureaucracy alone. This brings us to a critical junction in our study. If the attorney is the architect of the divorce, what happens when the architecture becomes too complex for the average person to understand? What happens when the very tools designed to ensure fairness become weapons of attrition? In the next part, we will peel back the curtain on the actual mechanics of the 21st century divorce firm. We will explore the tactical playbook used in high-stakes litigation and the secret history of how custody battles were used as leverage for financial gain. You will see how the modern attorney uses data and psychology to predict a judge's behavior before they even enter the courtroom. The era of the paper war is about to begin. The transition into the mid to late 20th century transformed the American divorce attorney from a courtroom orator into a strategic commander of information. This era, which legal historians often refer to as the rise of the discovery age, fundamentally changed the cost and complexity of ending a marriage. Imagine you are an attorney in 1985 named David. For the first time, you are dealing with the widespread adoption of the Xerox machine and early desktop computers. Before this, information was scarce and hard to duplicate. Now, for the first time, an attorney could bury the opposing counsel in a mountain of paperwork. This was the birth of the paper war. In this environment, the goal wasn't just to prove a point, but to increase the administrative burden on the other side. By requesting every bank statement, every receipt, and every diary entry for the last decade, an attorney could effectively stall a case or force a settlement by making the process too expensive to continue. The case studies of the 1980s illustrate this shift toward economic attrition. Consider a high-profile case from 1982 involving a corporate executive. The wife's attorney requested records not just of the executive's salary, but of his perquisites, use of the company jet, country club memberships, and deferred stock options. This was a relatively new frontier for the U.S. divorce attorney. They had to learn how to read a corporate balance sheet as well as they read a custody report. This required a step-by-step deconstruction of what constituted a marital asset. If the husband's career growth was fueled by the wife's unpaid labor at home, how do you put a dollar value on that contribution? Historical trends show that during this decade, the use of expert witnesses, specifically forensic accountants, became a standard practice for any middle to upper class divorce. By the time we reached the 1990s, the paper war evolved into the digital war. The introduction of email and the early internet meant that the divorce attorney was now a digital detective. Imagine if a client named Jennifer came to you in 1998. She suspects her husband has been funneling money into an offshore account. In 1950, that money was likely gone forever. But in the late 90s, your role as an attorney was to hire a technician to recover deleted emails from a hard drive, or to trace a wire transfer through an early electronic banking portal. This period marked the professionalization of the paralegal and the legal assistant as essential components of the divorce machine. The attorney became the head of a small intelligence agency, managing various streams of data to build a comprehensive narrative of the marriage's financial reality. The potential outcomes for clients began to hinge on the quality of their attorney's technical infrastructure. A firm that didn't have the capability to process thousands of digital documents was at a severe disadvantage. This led to a massive consolidation in the industry. Small solo practitioners who once handled a few divorces a year were pushed out by specialized boutique firms that focused exclusively on high-net-worth matrimonial law. These firms developed their own internal case studies and databases, allowing them to predict how specific judges in specific counties would rule on a particular asset division. This use of predictive analytics is not a new invention of 2026. Its roots are firmly planted in the data collection efforts of the late 20th century. As we analyze the historical trends of the early 2000s, we see the divorce attorney grappling with the concept of the permanent record. Social media platforms like MySpace and later Facebook provided a treasure trove of evidence. Suddenly, the old he said, she said arguments were replaced by timestamp photos and public status updates. An attorney's job now included a step-by-step scrubbing of their own client's digital presence, while simultaneously mining the opponents. This era introduced a new psychological tactic: the use of public shame as legal leverage. If an attorney could find evidence of a lifestyle inconsistent with a client's reported income on social media, the settlement negotiations could turn on a dime. Let's look at a scenario involving a public figure in 2012 named Mark. His attorney didn't just look at his bank accounts, they looked at his GPS data from his phone and his credit card pings. This level of granular detail allowed the attorney to construct a timeline that was nearly impossible to refute. This is the era where the term legal strategy truly became synonymous with information management. The U.S. divorce attorney became the gatekeeper of what information the court would see And more importantly, what information would remain hidden behind the shield of attorney-client privilege? In the current year of 2026, we are seeing the culmination of these trends. The modern attorney now uses artificial intelligence to scan through millions of pages of discovery in seconds, looking for inconsistencies in financial reporting that a human eye might miss. The paper war has been replaced by the algorithm war. But the core objective remains the same as it was in the 19th century: to secure the best possible position for the client in a system that is inherently adversarial. The data shows that while the technology has changed, the human elements, greed, fear, and the desire for a fresh start, remain the primary drivers of the industry. Case studies from the last 5 years show that the complexity of assets has reached an all-time high. Attorneys are now dealing with the valuation of influence. If a couple built a YouTube channel together, how do you divide the future earnings of that digital brand? If one spouse owns a significant amount of non-fungible tokens or operates a decentralized autonomous organization, how does the attorney ensure an equitable distribution? These are the questions that define the masterclass of 2026. The attorney must be a technologist. They must understand the step-by-step process of cold storage for digital assets and the legal nuances of smart contracts. Furthermore, the role of the attorney in the 21st century has shifted toward a more holistic approach to the family unit. We are seeing a move away from the winner-takes-all mentality toward a sustainable future model. This is particularly evident in custody law. Historical trends indicate a massive shift from sole custody to co-parenting as the default legal standard. The attorney's job is no longer just to win the child, but to architect a schedule that minimizes conflict and maximizes the potential outcomes for the child's development. This requires a deep understanding of child psychology and a willingness to work collaboratively with the opposing side, a stark contrast to the adversarial combat of the 1950s. However, this shift toward collaboration has its own set of risks. If both attorneys are focused on a friendly settlement, is the client's individual interests being fully protected? This tension between the collaborative ideal and the adversarial duty is the central conflict of the modern practice. It leads to the creation of shadow negotiations, where the real deals are made in hallways and private phone calls long before anyone steps into a courtroom. To truly understand the history of the U.S. divorce attorney, you have to look at these unwritten rules and the culture of the bar associations that govern them. The industry has become a self-sustaining ecosystem. From the court reporters to the forensic accountants to the software developers who build the discovery tools, the business of divorce is a massive contributor to the legal economy. But as we look toward the future, a new question emerges. As the system becomes more automated and data-driven, will the human attorney eventually be replaced by an interface? Or is the emotional complexity of a failing marriage something that an algorithm can never truly navigate? In the next part, we are going to dive into the most controversial aspect of the entire industry, the psychology of the retainer. You will learn the specific step-by-step methods attorneys use to manage client expectations while maintaining their own profitability. We will explore the billing war and how the very structure of the legal fee can influence the length and intensity of a divorce. You will see how the 2026 attorney balances the ethical duty to their client with the harsh reality of running a high-overhead business. The curtain is about to be pulled back on the financial heart of the divorce machine. The financial engine of the U.S. divorce industry is fueled by a mechanism that most people recognize but few truly understand: the billable hour and the evergreen retainer. To understand the history of the divorce attorney, we have to understand the evolution of how they get paid. In the early 20th century, legal fees were often flat rates or based on a loose understanding of the work performed. However, as the American legal system became more procedural and document-heavy, the billable hour became the gold standard. This shift fundamentally altered the relationship between the attorney and the client. Imagine if you are a client in 2026 named Robert. You walk into a high-rise office and are asked to provide a $20,000 initial retainer. This money isn't the total cost. It is a down payment held in a trust account. As the attorney works, they deduct their hourly rate, which in major U.S. cities can range from $400 to over $1,000, from that pile of cash. The psychology of the retainer is a fascinating study in behavioral economics. Historical trends show that the larger the initial retainer, the more committed the client feels to the litigation. This is known as the sunk cost fallacy. Once Robert has invested $30,000 into a case, he is less likely to walk away or settle for a less than ideal outcome, even if settling would save him $50,000 in future legal fees. The attorney, balancing their ethical duty to provide efficient counsel with the necessity of maintaining a profitable firm, must manage this tension daily. Case studies from the early 2000s show that the most successful firms were those that mastered the art of client expectation management. They provide a step-by-step roadmap of potential outcomes, but they also highlight the risks of every path, which necessitates more research, more filings, and ultimately, more billable hours. Let us look at a scenario involving the billing war. Imagine a case in 2026 where both spouses have hired top-tier representation. The husband's attorney files a 30-page motion for temporary support. The wife's attorney must now spend 10 hours reviewing that motion, 5 hours researching case law to rebut it, and another 10 hours drafting a response. Before a judge has even looked at the file, the combined legal fees for that single motion could exceed $25,000. This is the financial reality of high-stakes matrimonial law. The attorney's role has evolved into that of a high-level project manager, who must justify these costs to a client who is often in the midst of the most emotionally volatile period of their life. Data from the American Bar Association suggests that fee disputes are among the most common reasons for grievances filed against family law practitioners. To mitigate this, the modern attorney has developed sophisticated transparency tools. In 2026, Robert doesn't just get a paper bill at the end of the month. He has access to a real-time portal, where he can see exactly what his legal team is doing at any given moment. Every phone call, every email, and every minute spent reviewing a text message is logged. This granularity is designed to build trust, but it also highlights the commodification of the attorney-client relationship. The history of the profession is a transition from the attorney as a family confidant to the attorney as a high-precision service provider. The step-by-step process of managing a retainer also involves the dreaded evergreen clause. This is a contractual requirement that the client must replenish the trust account as soon as it drops below a certain threshold. If Robert's $20,000 retainer drops to $5,000, he must immediately deposit another $15,000 to keep the firm working. This ensures that the attorney is never working on credit. It protects the firm from the historical trend of clients refusing to pay their final bill once the emotional intensity of the divorce has faded and the final decree is signed. For the attorney, this is a matter of business survival. For the client, it can feel like a never-ending financial drain. Beyond the hourly rate, the history of the U.S. divorce attorney includes the rise of value-based billing in very specific contexts, though this is rare in family law due to ethical constraints regarding contingency fees. In most states, an attorney cannot take a percentage of the final settlement or the alimony award. This rule was established to prevent attorneys from discouraging reconciliation for the sake of a higher payout. However, the indirect costs are where the complexity lies. Attorneys in 2026 often coordinate with third-party vendors, private investigators, business appraisers, and vocational experts, whose fees are often passed through the law firm's billing system. Consider a case study from a 2024 California dissolution. The primary dispute was the valuation of a tech startup founded during the marriage. The attorney didn't just bill for their time. They managed a team of 3 forensic accountants and 2 industry analysts. The total cost for the valuation alone reached 6 figures. The potential outcomes of the case hinged entirely on which side's experts were more credible to the judge. In this environment, the attorney acts as a venture capitalist of sorts, deciding which expert investments are most likely to yield a favorable return for the client's position. Imagine if the legal system moved toward a flat fee model for all divorces. Historical trends in low-conflict jurisdictions suggest that this would drastically reduce the time cases spent in the system. However, the U.S. market has resisted this for complex cases because no 2 divorces are identical. An attorney cannot predict if a spouse will become suddenly litigious, or if a hidden asset will require 100 hours of digital tracking. Therefore, the billable hour remains the dominant, albeit controversial, backbone of the industry. It provides a flexible, if expensive, framework for addressing the infinite variables of human conflict. The financial heart of the machine is also impacted by the rise of unbundled legal services. This is a 21st century development where an attorney provides help with only specific parts of a case, such as drafting a single motion or showing up for one hearing, rather than providing full representation. This is a response to the data showing that a staggering percentage of Americans now navigate the family court system pro se, or without an attorney, because of the sheer cost. The history of the divorce attorney is currently at a crossroads. Maintain the high-touch, high-cost model of the past or adapt to a more modular, accessible future. As we look at the attorney's role in 2026, we see them using billing data as a diagnostic tool. By analyzing the cost-to-benefit ratio of certain legal maneuvers, they can advise clients like Robert on whether a particular fight is worth the investment. For example, spending $10,000 in legal fees to fight over a $5,000 engagement ring is a common pitfall that the modern, data-driven attorney seeks to avoid. This shift toward economic sanity in legal strategy is one of the most significant developments in the recent history of the field. But what happens when the financial interests of the firm and the emotional needs of the client are perfectly aligned to create a forever case? What are the specific tactics used to keep a case in a state of perpetual motion? In the next part, we will examine the controversial world of litigation conduct and the war of attrition. We will go step by step through the process of how an attorney can legally use the rules of civil procedure to exhaust an opponent's financial and emotional resources. We will look at the case studies of the longest-running divorces in U.S. history and the specific legal maneuvers that kept them alive for decades. The strategy of the long game is about to be revealed. The strategy of the long game is a sophisticated application of legal attrition that has evolved significantly from the late 20th century into our current 2026 landscape. To understand this, we must look at the procedural mechanics that allow a U.S. divorce attorney to extend a case beyond the standard timeline of 6 to 12 months. This is not about breaking the law. It is about utilizing the law to its maximum procedural extent. Imagine a character named Thomas, a high-net-worth individual in Chicago in 2026. Thomas is involved in a contentious dissolution where the primary objective is not a quick settlement, but the preservation of a specific corporate structure. His attorney might employ a step-by-step strategy of defensive litigation that relies on the sheer volume of the legal process to slow the momentum of the opposing party. The first step in this maneuver is the strategic use of interrogatories and requests for production. While discovery is meant to be a fact-finding mission, in a long-game scenario, it becomes a logistical hurdle. An attorney can legally issue hundreds of specific questions that require Thomas's spouse to track down records from 20 years ago. Historical trends show that when the cost of compliance exceeds the perceived value of the information, the opposing party often experiences decision fatigue. Case studies from the early 2010s highlight how attorneys use the transition from paper to digital records to create bottlenecks. If one side provides 10,000 unorganized PDF files, the other side must pay their legal team to categorize them. In 2026, even with artificial intelligence tools assisting in document review, the human oversight required to verify privileged information remains a significant and time-consuming expense. Next, we must examine the motion for continuance. This is a standard legal tool used when an attorney needs more time to prepare, but historically, it has been used as a tactical pause button. By citing the unavailability of an expert witness or the discovery of a new, minor financial account, an attorney can push a trial date back by 3 to 6 months. In the U.S. court system, which is already burdened by heavy dockets, judges are often inclined to grant these motions to ensure due process. However, for a spouse who is financially dependent on a temporary support order that might be lower than the expected final award, these delays have massive financial consequences. The potential outcomes of a year-long delay can include the depletion of savings or the forced sale of non-marital assets just to keep the lights on. A critical case study in this arena is the 2018 dissolution of a prominent real estate developer in New York. The case lasted over 5 years, not because of a lack of evidence, but because of a series of interlocutory appeals. These are appeals filed on specific rulings made by the judge before the final judgment is entered. Each appeal can take months to be heard by a higher court, effectively freezing the main case in place. The attorneys in this case were masters of the procedural playbook, arguing that every minor valuation ruling was a matter of constitutional significance. This historical trend illustrates how the law can be stretched to accommodate a client's desire to maintain the status quo for as long as possible. Imagine if you were the spouse on the receiving end of this strategy. You might find yourself in what is known as the discovery cul-de-sac. This happens when your attorney sends a request for information, the other side provides an incomplete answer, and you are forced to file a motion to compel. The judge grants the motion, but the other side provides another slightly incomplete answer, triggering the cycle all over again. By the time you reach a third hearing on the same issue, 6 months have passed and $20,000 in legal fees have been spent on a single bank statement. This is the war of attrition in its purest form. It is a psychological test of who will blink first. In 2026, the long game has added a new layer: the valuation of intangibles. As our economy becomes more reliant on intellectual property and digital presence, the divorce attorney has more room to argue. Consider a scenario where a couple owns a large-scale e-commerce brand. One attorney might argue for a valuation based on current cash flow, while the other insists on a multi-year projection of market trends and brand equity. This necessitates the hiring of multiple competing experts, each of whom must be deposed. A deposition is a step-by-step oral testimony taken under oath outside of court. In a high-stakes U.S. divorce, a single expert deposition can last 2 full days and cost upwards of $15,000 when you factor in the expert's fee, the court reporter, and the attorney's hourly rates. Data regarding these long-running cases suggests that they often end not with a judge's decision, but with a total collapse of one party's emotional or financial will. The U.S. divorce attorney must walk a very fine ethical line here. Under the model rules of professional conduct, an attorney has a duty to expedite litigation consistent with the interests of the client. However, if the client's interest is to delay, the attorney must find a legitimate legal basis for every action. This creates a culture of creative lawyering where the goal is to make the process so burdensome that the other side accepts a settlement they would have rejected on day one. Furthermore, we must look at the role of the guardian ad litem, or child representative in these extended cases. When children are involved, a long-running legal battle can lead to a phenomenon known as status quo bias. If a case takes 3 years to resolve, and the children have been living in a specific schedule for those 3 years, the court is historically less likely to change that schedule in the final decree. Therefore, for an attorney representing the parent who currently has more time with the children, every delay is a strategic victory. It solidifies the temporary arrangement as the permanent reality. Case studies of high-conflict custody cases in the 2020s reveal that the length of the litigation is often the strongest predictor of the final outcome. The attorney who can successfully navigate the long game ensures that their client's position becomes the foundation upon which the final judgment is built. This is why the initial phase of a divorce, the filing of temporary orders, is often the most aggressive part of the entire process. It sets the stage for the years of procedural maneuvering that follow. The historical trends of the American legal system show a gradual attempt to curb these tactics through the use of mandatory mediation and strict discovery deadlines. In many U.S. jurisdictions in 2026, judges are becoming more proactive, issuing scheduling orders that penalize unnecessary delays. However, the complexity of modern assets and the ingenuity of the legal mind mean that the long game is always evolving. For every new rule, there is a new procedural loophole. This is the reality of a system that prioritizes the right to a robust defense above all else. But as the long game reaches its limits, and the financial and emotional costs become unsustainable, the divorce attorney often turns to a different, more shadow-filled strategy. What happens when the courtroom is no longer the primary battlefield? What occurs when the most effective legal maneuvers are the ones that never appear on the official record? In the next part, we will explore the world of strategic leakage and the media as a legal tool. You will see how the modern attorney uses the court of public opinion to influence settlement negotiations behind the scenes. We will go deep into the ethics of the leak and how a well-timed news story can be more effective than a 100-page motion. The era of the publicity war is next. The publicity war is a high-stakes evolution of the traditional adversarial process, where the courtroom is no longer the only venue where a case is won or lost. In the U.S. legal system, divorce records are generally public documents unless a judge takes the rare step of sealing them. This accessibility creates a powerful, and often dangerous, tool for the modern divorce attorney. To understand the history of this tactic, we have to look at the rise of the tabloid era in the 1980s and 1990s, where high-profile celebrity splits became a form of national entertainment. Today, in 2026, this has shifted from the front pages of newspapers to the hyper-targeted algorithms of social media. Imagine a character named Amanda, a prominent tech executive in Silicon Valley. If Amanda is going through a divorce, her attorney isn't just worried about what the judge thinks. They are worried about what the shareholders, the board of directors, and the public think. The primary mechanism of the publicity war is strategic leakage. This is a step-by-step process where sensitive but legally obtained information is shared with media outlets to create leverage. It begins with the filing of a detailed, often inflammatory legal complaint. Because these documents are public record, journalists can report on the allegations, such as claims of financial mismanagement or personal misconduct, without fear of defamation suits. as long as they are accurately reporting on the court filing. The attorney's role here is to ensure the complaint is written not just for the judge, but for the headline. Historical trends show that a well-timed filing on a Friday afternoon can dominate the weekend news cycle, putting the other spouse on the defensive before their legal team even has time to draft a response. Case studies from the early 2020s highlight the use of the controlled leak to influence settlement negotiations. In one notable 2022 case involving a high-net-worth real estate mogul, the wife's legal team strategically leaked evidence of the husband's undisclosed offshore assets to a financial news outlet. This didn't just hurt his reputation, it caught the attention of federal regulators. The potential outcomes of such a move are dual purpose. It forces the hand of the spouse to settle quickly to avoid further exposure, and it establishes a narrative of dishonesty that the judge may subconsciously carry into the courtroom. For the attorney, this is a delicate dance with ethical boundaries. The American Bar Association's model rules generally prohibit attorneys from making extrajudicial statements that have a substantial likelihood of materially prejudicing an adjudicative proceeding. However, the line between providing a public record to a reporter and making a prejudicial statement is often thin. Imagine if you were the spouse being targeted by a PR-focused legal strategy. You might wake up to find your private text messages, which were produced during the discovery process, being discussed on a podcast or analyzed by a digital news site. The attorney's strategy here is to create a state of permanent crisis. This is often referred to as litigation by press release. By the time you get to trial, the public narrative is so firmly established that the facts of the case struggle to compete with the established fiction. In 2026, this has become even more complex with the rise of deepfake technology and synthetic media. Attorneys now have to hire digital forensic experts not just to find evidence, but to protect their clients from fabricated evidence being leaked to the public to destroy their credibility. The step-by-step implementation of a publicity strategy often involves the hiring of a litigation PR firm. These specialized agencies work alongside the legal team to manage the brand of the client. They analyze the potential outcomes of every court appearance and prepare talking points for the attorney to use on the courthouse steps. Historical trends suggest that in high-stakes U.S. divorces, the cost of the PR firm can sometimes rival the cost of the legal team itself. Data indicates that public perception can directly impact a person's career trajectory, especially for those in public-facing roles or leadership positions. Therefore, the divorce attorney is no longer just protecting a client's assets. They are protecting their client's future earning capacity. Consider a 2025 case study where a prominent influencer was sued for divorce. The husband's attorney used the discovery process to obtain the influencer's raw, unedited video footage and internal analytics. While these were relevant to determining the value of the marital business, the attorney ensured that the most unflattering parts of that data were highlighted in public motions. The influencer, fearing the loss of her audience and brand partnerships, agreed to a settlement that was significantly higher than what the law likely would have required. This is the power of the publicity war. It turns the legal process into a weapon of reputational destruction. Furthermore, we must examine the concept of the reverse leak. This is a defensive tactic where an attorney leaks information that makes their own client look like a victim or a sympathetic figure. By humanizing the client in the eyes of the public, the attorney can mitigate the impact of the negative information being released by the other side. This historical trend of humanization has become a staple of modern celebrity legal strategy. It involves a step-by-step rollout of positive stories, charitable donations, family-focused activities, or professional achievements that run parallel to the divorce proceedings. In 2026, the attorney acts as a chief communications officer, ensuring that every public move is synchronized with the legal strategy. The impact of this publicity on the judiciary is a subject of much debate. While judges are trained to be impartial and base their decisions only on the evidence presented in court, they do not live in a vacuum. They see the same news reports and social media trends as everyone else. The psychological concept of the halo effect suggests that if a judge views one party as a good person because of their public persona, they may be more likely to give them the benefit of the doubt in a close legal call. This is why the U.S. divorce attorney spends so much time on image management. It is a subtle long-term influence campaign aimed at the single most important person in the case, the individual in the black robe. However, the publicity war is a double-edged sword. Historical trends show that when both sides engage in aggressive media tactics, it often leads to a scorched earth scenario where neither party comes out ahead. The children of the marriage are often the most affected, as they can easily find the details of their parents' battle with a simple internet search. In 2026, many forward-thinking attorneys are beginning to push for private judging or arbitration to keep these matters entirely out of the public eye. This is a return to the privacy of the early 20th century, but it comes with a high price tag that only the wealthiest Americans can afford. The history of the divorce attorney is thus a history of the tension between the public's right to know and the individual's right to privacy. As we look at the evolution of these tactics, it is clear that the attorney of the future must be as comfortable in a television studio or a social media war room as they are in a courtroom. The publicity war has redefined the concept of professional advocacy, turning the legal professional into a multifaceted strategist who must navigate the complex intersection of law, media, and psychology. But even as the public battle rages, the most significant shifts in the industry are happening in the silent, automated systems that govern our lives. What happens when the human element of the publicity war is replaced by the cold logic of an algorithm? How do attorneys in 2026 handle the rise of automated settlement tools and AI-driven mediation? In the next part, we will explore the rise of the Silicon Valley divorce and the automation of the legal profession. You will see how big data is being used to predict the end of a marriage before the couple even knows it's over. The era of the predictive divorce is coming into focus. The era of predictive divorce represents the most radical shift in the history of the U.S. divorce attorney, moving the profession from a reactive state to a preemptive one. In the current landscape of 2026, the integration of big data and machine learning has created a system where the legal outcome of a marriage can often be determined before the first filing ever hits the court clerk's desk. To understand this, we have to look at the step-by-step digitization of the American household. Historically, an attorney had to wait for a client to walk through the door with a box of receipts. Today, the data trail begins years earlier. Imagine a character named Kevin, an engineer in Seattle. Kevin and his spouse have a smart home, shared streaming accounts, integrated banking apps, and wearable fitness trackers. In 2026, specialized legal tech firms use historical trends to analyze consumer behavior. Data indicates that specific changes in spending habits, such as a sudden increase in individual travel, shifts in grocery shopping patterns, or even changes in the frequency of communication via shared devices, can predict a marital breakdown with startling accuracy. For the modern divorce attorney, this data is the new gold mine. Case studies from 2024 and 2025 show that forward-thinking law firms are now using predictive analytics to offer what is known as marital audits. Instead of waiting for a crisis, an attorney uses software to scan a couple's financial and digital footprint to identify potential outcomes if they were to separate today. This is a far cry from the 19th century private investigator peeking through keyholes. This is a high-level data analysis that determines the exact percentage of marital versus non-marital asset growth over a 10-year period in seconds. The step-by-step process of predictive divorce often begins with sentiment analysis. Attorneys now have access to tools that can scan years of emails and text messages to determine the emotional trajectory of a relationship. While this sounds like science fiction, it is a grounded reality in high-stakes U.S. litigation. If an attorney can prove through a data-driven timeline that a spouse began checked-out behavior or financial dissipation 2 years before the actual filing, they can argue for a larger share of the assets based on the waste of marital funds. Consider the historical trend of the Silicon Valley divorce. In Northern California, the valuation of stock options and restricted stock units, RSUs, used to be a grueling process involving months of back and forth between experts. In 2026, attorneys use automated valuation engines that plug directly into corporate payroll systems and market data feeds. This has created a new standard, the automated settlement. Imagine if Kevin and his spouse decide to split. Instead of a year of depositions, their attorneys input their data into an AI-driven mediation platform. The software analyzes thousands of similar case studies in the Seattle jurisdiction and produces a range of potential outcomes that are statistically likely to be approved by a judge. This leads to a fascinating shift in the attorney's role. They are no longer the primary calculator of the deal, they are the auditors of the algorithm. Their job is to find the data points that the machine missed. This is the era of the legal data scientist. Historical data suggests that while algorithms are efficient, they struggle with the nuances of human contribution, such as the stay-at-home parent's role in supporting a high-stress career. The attorney in 2026 must argue against the machine's cold logic by providing qualitative context that a data point cannot capture. Step by step, the industry is also grappling with the rise of the divorce prophecy. There are now fintech startups that offer insurance-like products based on the statistical likelihood of a divorce. By analyzing a person's demographic, education level, and even their social media interactions, these companies can predict the risk of a future legal battle. For the U.S. divorce attorney, this means they are being consulted by individuals who aren't even married yet. Premarital planning in 2026 is no longer just about a prenup. It is about building a data-shielded life. Imagine if your attorney advised you to maintain separate digital identities from day one, specifically to prevent future sentiment analysis from being used against you. This is the level of strategic depth required in the modern age. We are seeing a historical trend where the law is becoming a branch of information security. Case studies of 2026 dissolutions often involve complex disputes over digital assets that didn't exist a decade ago. For example, the division of a decentralized autonomous organization, DAO membership, or the fractional ownership of a high-value NFT collection requires an attorney who understands blockchain architecture as well as they understand the tax code. Furthermore, the predictive era has changed the nature of child custody disputes. In 2026, parenting apps are often mandated by courts to track communication between separated parents. An attorney can now pull a report that shows, with mathematical precision, which parent is more cooperative. If one parent consistently responds to messages within 30 minutes while the other takes 48 hours, the data creates a narrative of neglect or obstruction. This is a step-by-step quantification of parental fitness that was impossible in the 1990s. The data from the U.S. Census Bureau and legal trade publications shows that this level of automation is actually leading to a decrease in the number of cases that go to a full trial. When the potential outcomes are so clearly predicted by the data, the incentive to fight a losing battle diminishes. However, this creates a new ethical dilemma. If the algorithm says you have a 90% chance of losing the house, will you even try to fight for it? The divorce attorney must now protect their client from algorithmic fatalism, the idea that the data has already decided their future. As we look at the historical trends, we see that the U.S. divorce attorney has evolved through three distinct phases: the moral advocate of the fault era, the financial strategist of the no-fault era, and now the data architect of the predictive era. Each phase has seen the attorney gain more power through the mastery of information. But as the information becomes more automated, a new shadow is falling over the profession. If a machine can predict the outcome of a divorce with 98% accuracy, why does the attorney need to exist at all? This question is at the heart of the current legal civil war. On one side are the traditionalists who argue that the human element of justice, empathy, equity, and discretion can never be automated. On the other side are the tech disruptors who believe that the legal system should be as seamless as an app on your phone. In 2026, the divorce attorney is caught in the middle, fighting to remain relevant in a world that is increasingly skeptical of high hourly rates for tasks that a computer can perform in seconds. What happens when the data doesn't just predict the divorce but actually causes it? What occurs when the legal system begins to reward those who can most effectively manipulate the algorithm? In the next part, we will explore the dark side of the modern practice, the rise of the synthetic spouse. You will learn about the use of AI-generated evidence, the manipulation of smart home data to create false narratives, and the new frontier of digital gaslighting in family law. We are moving from the era of information into the era of deception. The verification war starts now. The verification war represents a critical turning point in the academic study of the U.S. divorce attorney, marking a period where the primary role of the legal professional shifted from a gatherer of evidence to a gatekeeper of reality. In the current year 2026, the American courtroom has become the front line for a battle against synthetic deception. To understand this, we must examine the step-by-step process of how digital gaslighting has integrated into matrimonial litigation. Historically, an attorney's biggest challenge was a lying witness or a forged signature on a deed. Today, the challenge is a perfectly rendered audio recording of a spouse making a threat that never actually happened, or a deepfake video showing a parent in a compromising situation that was entirely generated by a local neural network. Imagine a character named Elena, a marketing executive in Austin. Elena is in the middle of a high-conflict custody battle. One morning, her attorney receives a file from the opposing counsel containing an audio clip of Elena, apparently admitting to substance abuse during her parenting time. The voice is hers, the cadence is hers, and even the background noise matches her living room. In 1996, this would have been a smoking gun. In 2026, Elena's attorney must immediately launch a step-by-step verification protocol. This involves hiring a forensic media analyst to examine the file's metadata and look for artifacts of generative AI. This specific historical trend has forced the U.S. divorce attorney to become an expert in digital provenance, the record of an item's existence, and its chain of custody in the digital realm. The potential outcomes for a case like Elena's are devastating if the attorney fails to detect the fraud. If the synthetic evidence is admitted, it can influence child custody evaluations, the division of assets, and even trigger criminal investigations. Case studies from early 2025 show a sharp rise in the use of AI voice cloning in family court. One specific case in Florida involved a husband who used a voice cloning app to create a series of voicemails from his wife, which he then used to obtain a temporary restraining order. By the time the attorney proved the voicemails were synthetic, the husband had successfully barred the wife from the family home for 3 months, establishing a new status quo for the court. This leads us to the new legal standard of the 2020s, the chain of authenticity. Modern attorneys now advise their clients to use specialized, encrypted communication platforms that timestamp and digitally sign every interaction. This creates a verifiable record that cannot be easily spoofed. The attorney's role is to build a wall of authentic data around their client to repel the inevitable wave of synthetic attacks. This is a massive departure from the 1980s, where an attorney's biggest technological concern was a tape recorder in a purse. Today, the attorney must understand the nuances of hash values and blockchain-based verification. The verification war also extends to the home environment. We are seeing a historical trend where smart home data is being manipulated to create false narratives of domestic life. Imagine if an attorney could prove that a spouse was never home by hacking into the smart thermostat or the smart lock to alter the entry logs. In 2026, divorce attorneys are increasingly calling on IoT, Internet of Things, forensic experts to testify. These experts perform a step-by-step audit of the home's digital ecosystem to ensure that the data presented in court accurately reflects reality. This level of technical scrutiny was once reserved for corporate espionage cases, but it has now become a standard part of the American divorce experience. Consider the case study of a 2024 dissolution in New York, where the primary evidence for a relocation request was a series of automated logs from a smart refrigerator and a security system. The attorney for the opposing side was able to prove that the logs had been remotely accessed and edited via a secondary administrative account that the client didn't even know existed. This discovery completely flipped the case, turning a routine custody matter into a high-stakes debate over digital fraud and evidence tampering. The attorney's ability to recognize the possibility of digital manipulation is now just as important as their ability to cross-examine a witness. Furthermore, we must address the rise of the synthetic spouse in social media. In the publicity war discussed earlier, we saw how real information is leaked to damage reputations. In the verification war, the leaked information is often entirely fabricated. Attorneys in 2026 frequently deal with shadow accounts that post AI-generated photos of their clients in compromising positions, designed to be seen by the client's professional network or the court's social workers. The attorney's strategy involves a step-by-step process of issuing subpoenas to platforms to track the IP addresses of these accounts, while simultaneously filing motions for emergency sanctions. The data suggests that the U.S. legal system is struggling to keep pace with the speed of these technological advancements. While the federal rules of evidence have been updated to address electronic records, the specific challenges of generative AI remain a gray area. This creates an environment where the most technologically savvy attorney often has a significant advantage. It is no longer enough to be a good lawyer, you must be a digital defender. The historical trends show that as the cost of creating synthetic evidence drops, the cost of verifying authentic evidence rises. This further widens the gap between those who can afford elite legal representation and those who cannot. Imagine if every piece of evidence in a divorce had to be verified by a third-party AI auditor before it could be seen by a judge. This is a potential outcome being discussed by legal reformers in 2026 to combat the flood of fake data. The U.S. divorce attorney of the future may find themselves in a system where the human element of judgment is preceded by a mandatory layer of machine verification. This transition reflects a broader societal loss of trust in digital information, a loss that is felt most acutely in the high-stakes, emotionally charged world of family law. As the attorney navigates this era of deception, they must also manage the psychological toll on the client. Being the victim of digital gaslighting is a traumatic experience that can impair a client's ability to participate in their own defense. The attorney must act as a grounding force, using objective, verified data to help the client distinguish between reality and the synthetic narrative being pushed by the opposition. This requires a level of emotional intelligence and technical expertise that defines the masterclass level of the 2026 matrimonial practitioner. But even as we master the technology of the present, a larger, more systemic shift is occurring. The very foundation of the American divorce is being re-evaluated through a global lens. What happens when the assets are not just digital but extraterritorial? How does the U.S. divorce attorney handle the rise of the international asset fortress and the emergence of global jurisdictional shopping? In the next part, we will explore the world of the sovereign divorce and the global elite. You will see how the world's wealthiest individuals use international law and private jurisdictions to bypass the U.S. court system entirely. We are moving from the home to the world stage. The era of the jurisdictional game is about to begin. The jurisdictional game is the ultimate frontier for the high-net-worth U.S. divorce attorney, a complex chess match played across borders where the board is the entire globe. In 2026, the concept of a marriage being confined to a single state's laws is an antiquated notion for the American elite. To understand this academic shift, we must look at the step-by-step process of forum shopping. This is a strategy where an attorney analyzes multiple possible jurisdictions, be it London, Dubai, Singapore, or the Cayman Islands, to determine which legal system offers the most favorable potential outcomes for their client. Historically, the U.S. was the primary battleground, but as capital became more fluid and digital, the divorce attorney's role evolved into that of an international jurisdictional architect. Imagine a character named Christopher, a venture capitalist with homes in New York, London, and the British Virgin Islands. When his marriage begins to dissolve in 2026, his attorney does not simply file in Manhattan. Instead, they launch a comprehensive jurisdictional audit. If Christopher is the primary earner, his attorney might favor a jurisdiction that limits alimony or has a narrower definition of marital property. Conversely, if Christopher's spouse is the one filing, they might push for London, famously known as the divorce capital of the world for its generous awards to non-earning spouses. This isn't just a choice of convenience. It is a multi-million-dollar calculation based on historical trends of international judicial behavior. The first step in the jurisdictional game is the race to file. In many international legal frameworks, the court that receives the petition first is the one that retains jurisdiction. This creates a high-pressure environment where a U.S. divorce attorney must coordinate with international counsel in real time, often across multiple time zones, to ensure their client wins the race. Data from 2025 indicates that the time between a client's first consultation and a filing in an international jurisdiction has shrunk from weeks to mere hours. Case studies of high-profile tech founders show that an attorney might have a private jet on standby or use encrypted, high-speed legal filing portals to secure a favorable forum before the other spouse even realizes the marriage is over. Once a jurisdiction is secured, the next phase is the asset fortress. This involves the use of offshore trusts and shell companies to move marital assets out of the immediate reach of a U.S. court. While U.S. judges have broad powers to order the return of assets, their ability to enforce those orders in a foreign country is often limited by international treaties and the domestic laws of the offshore haven. A U.S. attorney in 2026 must be well-versed in the Hague Convention and the specific step-by-step procedures for domesticating a foreign judgment. They work alongside international tax specialists to ensure that every movement of capital is legally defensible, framing it as legitimate business restructuring rather than a fraudulent conveyance. Consider the case study of a 2024 dissolution involving a multinational shipping magnate. The husband's legal team had spent 5 years moving assets into a series of Cook Islands trusts. These trusts are specifically designed with high barriers to entry for creditors and ex-spouses. The U.S. attorney for the wife had to engage in a step-by-step forensic hunt, utilizing international subpoenas and whistleblowers to prove that the husband still retained control over the assets. This historical trend highlights the shift from domestic litigation to international intelligence gathering. The divorce attorney is now a coordinator of global investigations, managing teams in multiple countries to pierce the corporate veil. Imagine if your attorney advised you to change your legal domicile to a different country entirely to protect your future earnings. This is a reality for the global elite in 2026. This process, known as expatriate divorce planning, involves a step-by-step transition of residency, tax filings, and physical presence to establish a new legal home. The attorney must navigate the complex U.S. exit tax laws, while simultaneously building a narrative of a legitimate move. This strategy often relies on the concept of comity, the legal principle where one country recognizes the judicial acts of another. If an attorney can secure a divorce decree in a favorable foreign country, they then work to have that decree recognized by U.S. courts, effectively bypassing less favorable domestic laws. The data shows that this jurisdictional complexity has led to the rise of the International Prenuptial Agreement. In 2026, these are not just simple contracts. They are massive legal documents that specify exactly which country's laws will apply and which courts will have jurisdiction, regardless of where the couple is living at the time of the split. These agreements often include choice of law clauses that are tested in multiple jurisdictions simultaneously. The U.S. divorce attorney must ensure that the agreement is robust enough to survive the scrutiny of a judge in Paris, just as much as a judge in Los Angeles. Furthermore, we must address the role of the sovereign divorce in the world of private wealth. Many ultra-high net worth individuals are now turning to private arbitration and private judges located in neutral territories. This allows them to settle their affairs away from the public records of any national court. This is a step-by-step privatization of the legal system, where the rules of the divorce are essentially written by the attorneys themselves through a private contract. Historical trends suggest that as public courts become more backlogged and digitized, the elite will continue to migrate toward these private, high-security legal enclaves. The jurisdictional game also introduces the concept of the blocking statute. Some countries have passed laws specifically designed to prevent their citizens' data or assets from being used in foreign legal proceedings. A U.S. attorney in 2026 might find themselves in a stalemate where a U.S. judge orders the production of documents that a Swiss or Caymanian law forbids them from releasing. Navigating these conflict of law scenarios requires a deep understanding of international diplomacy and private international law. The attorney must act as a legal diplomat, negotiating between two competing sovereign powers to find a path forward for their client. The potential outcomes of these international battles are often measured in the billions. When a single jurisdictional decision can swing a settlement by hundreds of millions of dollars, the pressure on the legal team is immense. This has led to the emergence of the global matrimonial firm, massive organizations with offices in every major financial center, specifically dedicated to the art of the international split. The history of the U.S. divorce attorney is no longer a domestic story. It is a story of how American legal principles are being challenged, adapted, and sometimes circumvented by the forces of globalized wealth. As we reach the final stages of our academic study, we see a profession that has moved from the local courthouse to the global stage. But even as the elite play the jurisdictional game, the vast majority of Americans are facing a very different reality. While the few use international law to protect fortunes, the many are dealing with a system that is becoming increasingly unbundled and automated. This brings us to the final, and perhaps most important part of our journey. In the final part, we will explore the great bifurcation of the legal profession. We will look at the future of the U.S. divorce attorney in a world of extreme inequality. You will see the final step-by-step evolution. The rise of the concierge lawyer, for the 1% and the automated justice for everyone else. We will conclude our masterclass by looking at the ethics of a two-tier legal system and the ultimate fate of the profession as we move toward the mid-21st century. The end of the history of the divorce attorney and the beginning of whatever comes next is only one part away. The final decree is coming. The great bifurcation of the American legal system is no longer a theoretical projection. In 2026, it is the lived reality of the family law practitioner. As we conclude this academic study, we must examine how the profession has split into two entirely different species. On one side, we have the concierge lawyer, a high-touch, multidisciplinary strategist for the ultra-wealthy. On the other, we have the rise of automated justice, a streamlined, algorithm-driven process for the general public. This final step-by-step evolution reveals the ultimate fate of the U.S. divorce attorney as we approach the mid-21st century. Imagine a character named Sarah, a middle-class teacher in Ohio. For Sarah, the traditional model of a $20,000 retainer is an impossibility. In 2026, her interaction with the legal system is primarily through a public interface portal. This is the first step of the automated justice track. Historical trends show that since 2020, over 80% of civil litigants in many U.S. jurisdictions are self-represented. To handle this volume, courts have implemented AI-guided filing systems. Sarah inputs her financial data, her children's schedules, and her housing needs into a secure government server. The system then generates a standardized settlement agreement based on state statutes and historical sentencing data. The attorney's role in Sarah's world has been reduced to a document auditor, a legal professional who reviews the machine-generated output for a flat fee of $500, ensuring no glaring errors were made before the digital judge signs off. Contrast this with a character named Julian, a hedge fund manager in Manhattan. Julian's experience represents the concierge model. His attorney is not just a lawyer. They are the leader of a domestic management team. This team includes a full-time forensic accountant, a private security detail, a reputation management consultant, and a therapeutic mediator. The step-by-step process for Julian is not about filing forms. It is about creating a customized legal reality. The potential outcomes for Julian are negotiated in private clubs and secure digital rooms, completely bypassing the public court dockets that Sarah must navigate. This historical trend of private judging has created a shadow legal system where the wealthy can resolve their disputes with absolute privacy and tailored results. The data regarding this bifurcation is striking. While the number of traditional family law firms is shrinking, the revenue of elite matrimonial boutiques is at an all-time high. This suggests that the value of the U.S. divorce attorney has shifted from mere procedural knowledge to high-level strategic protection. For the general public, the law has become a commodity. For the elite, it is a bespoke service. This leads to a significant ethical question. If the law is the same for everyone, why are the outcomes so vastly different based on the delivery method? Case studies from 2025 highlight the risks of this two-tier system. In one instance, an automated system in a southern state failed to account for a complex pension plan in a pro-se divorce, resulting in a spouse losing hundreds of thousands of dollars in future benefits because they didn't have a human attorney to flag the omission. Conversely, in the concierge world, attorneys are using sophisticated tax straddling techniques to preserve wealth in ways that a standardized algorithm would never suggest. The attorney in 2026 must decide which side of this divide they want to occupy. Those in the middle, the small-town generalists, are being squeezed out by the efficiency of the software on one side and the resources of the boutiques on the other. The final step in this evolution is the emergence of the preventive legal architect. In the final years of our study, we see attorneys moving away from the dissolution of marriage and toward the engineering of the household from the outset. This involves the use of dynamic prenuptial agreements that adjust automatically based on the birth of children, the growth of assets, or even the frequency of relocation. These contracts are monitored by smart contract technology, which can trigger automatic asset transfers or support payments without the need for a court order. The attorney becomes the programmer of the domestic contract, setting the rules that will govern the family for decades. Imagine if your marriage contract was as complex and as frequently updated as a software license agreement. This is the potential outcome of the high-end legal market. The attorney's job is to ensure that the contract is robust enough to survive the next 20 years of technological and social change. This shift from reactive litigation to proactive architecture represents the highest level of the profession. It requires a deep understanding of future trends, including the legal status of artificial identities, the inheritance of digital consciousness, and the jurisdictional challenges of a spacefaring or highly mobile society. As we look toward 2030 and beyond, the history of the U.S. divorce attorney will likely be defined by the tension between human intuition and algorithmic precision. Historical trends suggest that the public will continue to demand faster, cheaper, and more transparent legal services, which will further drive the automation of the general practice. However, the human need for an advocate, someone to stand in the breach during the most difficult moments of a person's life, is unlikely to disappear. The attorney who can bridge the gap between high-tech efficiency and high-touch empathy will be the one who survives the great bifurcation. The academic study of this profession reveals that the divorce attorney has always been a mirror of American society. When we were a religious society, they were moral arbiters. When we became a corporate society, they were financial strategists. Now, as we become a data-driven society, they are information architects. The story of the divorce attorney is the story of how we define our most intimate bonds and how we manage the inevitable friction when those bonds break. It is a story of power, money, and the search for a fair resolution in an unfair world. Step by step, we have traced the path from the colonial magistrate to the AI-augmented global strategist. We have seen how the law can be used as a shield, a sword, and a blueprint. We have explored the secret tactics of the paper war, the publicity war, and the jurisdictional game. Through case studies and data, We have demystified a profession that is often misunderstood and unfairly maligned. The history of the U.S. divorce attorney is ultimately an academic study of the human condition itself, our resilience, our greed, our capacity for change, and our constant drive for justice. The final decree is not just a legal document. It is the end of one chapter and the beginning of another. As the legal profession continues to evolve, the lessons of the past remain our best guide for the future. Whether the future is one of automated efficiency or elite concierge service, the core mission of the advocate remains unchanged: to bring order to the chaos of a life in transition. But even as this masterclass ends, a new question arises for the next generation of practitioners and citizens alike. In a world where every asset is tracked, every word is recorded, and every outcome is predicted, is there still room for the unexpected? What happens when the legal system finally achieves perfect efficiency, and the element of chance is removed from the pursuit of justice? To answer that, we must look beyond the history of the attorney and toward the future of the human heart. The study continues, but for now the record is closed.